Our first speaker this morning is law professor David N. Mayer. He is an expert on constitutional history. He's written, for example, on the constitutional thought of Thomas Jefferson. Please welcome David Mayer.
Thanks. Well, yesterday in part one, I talked about the office of the presidency as created by the framers of the Constitution, and how for the first 100 years or so of government under the Constitution, the American presidents largely kept within bounds, within the constitutional limits set by the document, what Thomas Jefferson referred to as the chains of the Constitution. Today in part two, I get to the depressing part. What has happened over the last 100 years as U.S. presidents have loosened themselves from their constitutional moorings and have caused us to mourn a imperial presidency, a dictatorial presidency, a presidency that in effect is an elective monarchy, as Thomas Jefferson warned it might become. But never fear, I hope to identify at least a couple silver linings in that dark cloud before we're finished today. The transformation of the presidency began in the first 2 decades of the 20th century during the so-called progressive era. Now, I always say so-called progressive era because, as most of us know, all of us I think know, there's nothing progressive about the progressive movement of the early 20th century. It's actually reactionary, as a return back to paternalistic government policies, a statist paternalistic government of centuries ago. So it was a movement backward rather than forward, the very opposite of what a truly progressive movement would be. But the so-called progressive reformers, because they wanted bigger government, more intrusion in individuals' lives, had nothing but disdain for fundamental American constitutional principles like limited power, the enumeration of federal powers, separation of powers, and checks and balances. And we can see with the two so-called progressive presidents of the early 20th century, one Democrat, one Republican, how the presidency itself was transformed. Theodore Roosevelt, in his autobiography, Roosevelt being a progressive Republican, he said this about his powers as president, quote, "Occasionally great national crises arise which call for immediate and vigorous executive action. In such cases, it is the duty of the president to act upon the theory that he is the steward of the people and that the proper attitude for him to take is that he is bound to assume that he has the legal right to do whatever the needs of the people demand unless the Constitution or the laws explicitly forbid him to do it." Now notice how this turns entirely on its head, the fundamental doctrine of enumerated powers. As I pointed out yesterday, the president has only those powers that the Constitution explicitly gives him. The virtual opposite of what Roosevelt's stewardship theory of the presidency would suggest. That's bad enough, but then TR was followed in the White House after an intermediate period with Taft as president by another progressive, this time a Democrat, Woodrow Wilson. Wilson came to the White House from Princeton University and the governorship of New Jersey. He was former president of Princeton. Very dangerous having a university president as president of the United States or holding any kind of political office, because they're used to dictatorial powers already as a university president, and then go into the White House and then assume that they can exercise those same kind of powers. It's especially compounded by the fact that Wilson was enamored with the British parliamentary system. He had explicit disdain for the American principle of separation of powers. He envisioned the office of president as something more like the British prime minister. As we'll see, during his presidency, set some very important precedents that have led to the enormous powers that 20th and now 21st century presidents exercise. Now, I suggested that the progressive movement itself, with its contempt for constitutional limitations, was key in this transformation of the presidency. But there was one other very important reason, and that was the change, fundamental change, in American foreign policy since the time of the Spanish-American War under McKinley, when the United States ceased being the city on the hill, the country that would provide an example to the rest of the world of a constitutionally limited Republican government that safeguarded individual rights, and instead became an imperial power acting like the countries of Europe. And when we became involved in more foreign wars, the power of the presidency also increased. Libertarian Robert Riggs wrote a very interesting book many years ago called Crisis and Leviathan. And Riggs' thesis was that whenever the country went to war, there was a ratcheting up effect of government powers. The powers of government increased and permanently increased. They did not return to the pre-war levels. And so he argues in that book there's a correlation between war and increased powers of the national government. I think he's quite right about that. But one can add that, moreover, within the national government, the power of the presidency has increased vis-a-vis the other two branches, the Congress and the Supreme Court. And particularly with regard to the war powers, which, as I talked about last time, the president shares with the Congress, or is supposed to share with the Congress. Now, from 1789 to 1945, except for the Civil War, all major military actions taken by the United States were at the initiative of Congress. Congress either declared war or authorized war. That was true with regard to the Barbary War during Jefferson's presidency that I talked about yesterday, the War of 1812, the Indian Wars, the war against Mexico in 1846, the Indian Wars after that in the post-Civil War period, and the Spanish-American War of 1898, as well as both world wars, World War I and World War II. Then after World War II, with the ratification of the United Nations treaties, U.S. presidents began the practice that continues to this day, as we all know, of initiating wars themselves, without consulting Congress, without any kind of formal declaration of war or authorization of war, except sometimes after the fact, when it's almost too late for Congress to pull back and stop a war which a president has already begun. That unfortunate precedent, a series of precedents, of course, began with Harry Truman and Korea, the Korean conflict in 1951, when Truman sent U.S. troops to the Korean Peninsula to participate in a United Nations-sanctioned police action to counteract communist North Korea's invasion of South Korea. Now, President Truman and his supporters cited the UN Charter and the treaty that the United States had signed. Some legal scholars have even argued that the New World Order created by the United Nations Charter has made irrelevant a formal declaration of war that the framers envisioned in giving Congress that power under Article I, Section 8. But notice there's a problem with that argument, fundamental problem, and that is that the President and the Senate together in creating a treaty, in ratifying the United Nations Treaty, cannot amend the Constitution. There's only one way the Constitution can be amended, through the formal process of Article 5. The Constitution has not been amended. Congress still has the exclusive power to declare war, which, as I explained yesterday, was intended to chain the dog of war by giving to the people's representatives the power, the exclusive power, to determine when and where U.S. military force should be used. The American people pay for wars through their lives, through their taxes, and they have a right through their direct representatives in Congress to give their permission, essentially, for the United States to go to war. That principle is violated when presidents initiate wars themselves, even if they cite treaty obligations to do so. Of course, that was exactly the same way in which we got involved in Vietnam. President Kennedy first sent military advisors there, and then his successors, Johnson and Nixon, escalated the Vietnam War. The Gulf of Tonkin resolution, passed by Congress in 1964, has been regarded by some scholars as a kind of de facto authorization of war, where Congress gave President Johnson essentially a blank check to take action to protect American forces who were already there, because he had sent them there against a North Vietnamese action or offensive. But again, that falls far short of a formal declaration of war, and it's an example of a trend that has happened with these president-initiated wars, and that is congressional abdication of its constitutional power, and many would say its constitutional responsibility to exercise those powers. Congress essentially has acquiesced in this tremendous power grab by U.S. presidents to seize the war power onto themselves. Because Vietnam went on for so many years, was so controversial because of the draft, and tens of thousands of Americans were killed, Congress, late in the war, in 1973, during Nixon's presidency, tried to reassert Congress's power to declare war by passing, over Nixon's veto, the War Powers Act of 1973. The War Powers Act sets up a mechanism whereby if U.S. troops are in foreign territory in a situation where hostilities are imminent, a time frame begins. The clock starts ticking, and within a certain number of days, either Congress must declare war or authorize the action, or declare that there is an emergency. The problem with the war, well, there are several problems with the War Powers Act. People who take a broad view of Congress's power, its exclusive power to declare war, say it doesn't go far enough in restoring what is truly congressional prerogative. People who take a broad view of presidential power, of course, argue that the War Powers Act is an intrusion on the president's authority. Usually they cite the Commander-in-Chief clause, which is really an erroneous interpretation of that clause, because as I explained yesterday, the Commander-in-Chief power essentially gives the president the power to determine how to wage war once Congress has decided that we are to wage war, not the power to make that initial decision. But no president, Democrat or Republican, since Nixon, has really followed the terms of the War Powers Act, because they view it as an unconstitutional intrusion on presidential powers. And so this unfortunate practice of presidents involving the United States in wars not authorized in advance by Congress continues. The first Gulf War under George Bush the Elder, the incursion into former Yugoslavia, Bosnia, during Clinton's presidency, the wars in both Iraq and Afghanistan under President Bush the Younger. In the case of both Bushes, Congress did authorize action, pass essentially blank check authorizations. In the case of the first Gulf War, it happened months after U.S. troops had already been sent to the Middle East and were poised to attack Iraq. And some of you may remember in the 11th hour, in February of 1991, Congress finally voted to authorize the use of military against Iraq, another one of these so-called de facto declarations of war. And as I think most of us know or remember, after the 9/11 attacks, Congress passed resolutions giving Bush the younger the authority to go after whomever he believes was involved in the attacks, which was really the presumed authority for both the second war in Iraq and the war in Afghanistan. So, presidentially initiated wars is one great example of abuse of the war power, so-called war power, and particularly the commander-in-chief power. Let me mention just a couple other examples of abuses of the commander-in-chief power. During Truman's presidency, during the Korean conflict, there was a strike threatened in the U.S. steel industry, and Truman, citing both his general executive power and his power as commander-in-chief during time of war, even though it wasn't a war, it was a police action, it was a conflict, seized control of the steel mills. The owners challenged that in the famous Supreme Court case, Youngstown Sheet and Tube versus Sawyer. And in 1952, the court, that time, upholding the Constitution, held that Truman did not have that power. They shot down both the executive power argument and the commander-in-chief argument. Maybe most importantly, what the court said in its decision was that the president is obliged to act through the laws passed by Congress. Congress had passed a law that dealt with precisely this situation. There's a provision in the Taft-Hartley Act of 1947 that enabled the government to get an injunction against a strike if it might threaten national security. But instead of working through the law that had been passed by Congress, Truman did it on his own. The court quite rightly slapped him down for doing that. That case kind of stands out because often in the area of war powers, and particularly if there's a conflict between the president and the Congress, such as in several lawsuits that had been filed during the Vietnam era and up to the present day, challenging the legitimacy of wars. Generally, the federal courts won't act. They cite a doctrine called the political questions doctrine, where courts are reluctant to enter into disputes between the political branches, the legislative and executive, the Congress and the president, saying that those kind of questions are non-justiciable. They're not capable of being decided by the courts because they are political. But thankfully, in the Youngstown case, the court did hold that what Truman did was unconstitutional because it invaded property rights that should be protected under the Fifth Amendment against deprivation without due process of law. So because individual rights were at stake in that case, the court did act as it properly should. Let me move on to other abuses of power by modern presidents throughout the 20th century and now into the 21st century. And again, I think what the record of the modern presidents, Democrat and Republican, show over the past 110 years or so is that the office has, in many respects, been transformed into what Jefferson most feared, a tyrannical executive, in effect an elective monarch, someone who acts as if he is not bound by the chains of the Constitution. I'm going to talk about several different kinds of presidential abuse of power, starting with the veto power. I mentioned yesterday how the veto was intended by the framers of the Constitution as a protection against unconstitutional legislation, and that was the way the early presidents used the veto power. That continued throughout the 19th century. After the Civil War, there was an increase, though, in the number of presidential vetoes. President Grant vetoed over 40 bills. Grover Cleveland, in many respects the last Jeffersonian Democrat president, vetoed over 480 bills, more than his predecessors combined. All of them, though, on constitutional grounds or quasi-constitutional grounds. Why this tremendous increase in use of the veto power, even if it's limited to constitutional grounds? Well, after the Civil War, there was a rise in the number of so-called private bills in Congress. These were bills generally appropriating money for Civil War veterans or their widows beyond those general laws that provided for pensions for them. The general law really did not provide much, and many people, to use a modern term that some people use, fell between the cracks, and so you had all of these pleas for additional support for individuals. Cleveland, who is perhaps most famous for my favorite Cleveland quote is when he said, the people should support the government, not the other way around. The government should not support the people. And he vetoed these bills saying they violate very important 19th century constitutional principle, prohibition on what was called class legislation, laws that gave special benefits to some individuals that weren't generally available to others on equal terms. So throughout the 19th century, even as presidents increased the use of the veto power, they still limited it to what we could regard properly as unconstitutional legislation. Now that changed in the 20th century, and the president who changed it the most was the other Roosevelt, Franklin Delano Roosevelt, FDR. He vetoed over 600 bills when he was president, despite having huge Democrat majorities in both houses of Congress. Now, why did he veto so many bills? Well, FDR was the first president to use the veto as a purely political tool. In the words of presidential historian Forrest McDonald, FDR used the veto, quote, as a method of cracking the whip to keep Congress subordinate, if not subservient. In other words, he would tell a member of Congress, I'm going to veto this bill, your pet project, unless you support me on this other bill. And that began the modern practice of presidents vetoing legislation on policy grounds. Truman vetoed over 175 bills, despite the fact that he ran against the Republican Congress of 1947 to 49, the 80th Congress, calling it a do-nothing Congress. Well, it was apparently doing something because he was vetoing all the legislation that they were passing and then criticizing them for doing nothing. What's the problem with this? Well, it's an abuse of the veto power, going beyond what the framers intended as a shield against unconstitutional legislation, and essentially usurps Congress's legislative power. There's an additional problem with the veto. Remember, the presidential veto is not an absolute one. It's a limited veto. It can be overturned by a 2/3 vote of both houses of Congress. But if presidents use the veto power extensively and veto bills on policy grounds, simply because they don't like them, Democratic presidents who don't like bills because they don't spend enough money, Republican presidents who don't like bills because they don't give the executive enough power to fight the war on terror. Either way, if they do it on policy grounds, they're in effect transforming that simple majority for passage of bills by both houses of Congress into a 2/3 majority. So they are in effect amending the Constitution, again without a valid constitutional amendment. Now, modern presidents have turned the veto power entirely on its head, using it for only political purposes, not for constitutional purposes. A great example, and the reason why they do that, by the way, is that they show complete deference to the federal judiciary, to the Supreme Court and the other federal courts, to exercise their power of judicial review. Presidents, even though they take an oath to support the Constitution, even though early presidents, and particularly Jefferson, took the view that presidents were entitled in using the powers of their office to interpret the Constitution themselves. Andrew Jackson, for example, vetoed a bill chartering the second bank of the United States. Even though the Supreme Court upheld it as constitutional, Jackson said, when I exercise the veto power, I'm entitled to my own independent interpretation of the Constitution. I took an oath to defend it, and by God, I'm sure that this bill exceeds the powers of Congress. The bank is not constitutional, and on that grounds, those constitutional grounds, he vetoed the bill rechartering the second bank. But modern presidents, even if they are genuinely concerned that legislation might be unconstitutional, defer entirely to the courts. The most famous example in recent times that I can think of is George W. Bush with the McCain-Feingold law, a law that he knew violated the First Amendment through its restrictions on campaign finance, campaign expenditures, and yet he declined to veto it because he trusted to the courts to hold the law unconstitutional, and of course the court did not. It largely upheld the law. As we all know from this week's developments with the Supreme Court decision in the so-called health care law, I always hate when people refer to it as a health care law. It doesn't really deal with health care. It is the federal health insurance regulatory law, and by upholding it, the court failed to do its duty. We cannot rely on the Supreme Court and other federal courts to enforce constitutional limits on government, the chains of the Constitution. Presidents have to exercise their veto power on constitutional grounds to act as an additional check that the framers intended, and presidents also need to stop using the veto power on political grounds. Since I mentioned the so-called health care decision, so many people have been asking me about it at this conference. I wanted to take a brief digression, no more than 5 minutes, to talk a little bit about the law, talk about the Supreme Court decision, and to identify what I see as really a silver lining in the court's decision. The good news is it's not as bad as everybody is saying, as the newspaper headlines would suggest. You know, when you read the newspapers, what everybody is saying is the court by a 5-4 decision with Chief Justice Roberts joining with the 4 leftists on the court, upholding so-called Obamacare, the federal insurance regulatory law. You have to look more closely at what the court actually decided to see the good news in the decision. Thankfully, there's an excellent article about this in today's Washington Post. If you want to read more about this, I strongly recommend this. Randy Barnett, libertarian law professor at, of all places, Georgetown, who really was I would say, the intellectual leader of the constitutional challenge to the federal health insurance law, has an op-ed in the Outlook section of today's Washington Post on July 1st, 2012. And he, it's entitled, "We Lost, but the Constitution Didn't." And further on in the second page of the article, "The Constitutional Silver Lining in the Obamacare Debacle." Professor Barnett points out that those who are challenging the constitutionality of the law, won on most of the arguments that were advanced. The court, in his words, and he's quite right in saying this, definitively ruled that the Commerce Clause, the Necessary and Proper Clause, and the so-called spending power have limits, that the mandate to purchase private health insurance, as well as the threat to withhold Medicaid funding unless the states agreed to expand their coverage, exceeded those limits, and the court will enforce those limits. On all of those points, Chief Justice Roberts sided with the 4 dissenters. The dissenters, by the way, wrote a magnificent opinion. Some law professors have speculated, I think with good reason, that the dissenting opinion reads like a majority opinion. It has a long section on the issue of severability. If the individual mandate is unconstitutional, does the whole law go down? And the dissenter said, yes, it does. They refer to Justice Ginsburg's concurring opinion as a dissenting opinion. So there's a lot of evidence in that superb opinion, jointly written under the names of Justices Kennedy, who turned out to be, people thought he might be the waffler, but he was solid in this case. Kennedy, Scalia, Thomas, and Alito, joined by Roberts on these key decisions, said individual mandate is not justified under the Commerce Clause. Commerce Clause has limits. The necessary and proper clause cannot be used as a backup to justify it. Even if it's necessary, the dissenter said, and Roberts agreed, it is not proper as a means for making these reforms effective. And on the issue of coercing the states to change their Medicaid programs by using the spending power, the court, it wasn't just Roberts and the 4 dissenters, but it was joined by 2 of the leftists on the court, Kagan, of all people, and Breyer. So it was a 7-2 decision saying Congress can't coercively use its Medicaid decision. So in those respects, despite the very troubling ruling by the Chief Justice that it's a tax and so on, when it comes to the commerce of power and the necessary and proper power and limits on the spending power, the people who are making the constitutional argument against the law essentially got the holding that they wanted from the Supreme Court. And as Randy says, as troubling as it is, the holding on the tax, that in many ways the taxing power is not as dangerous as the commerce power. And I'll leave his article for you to ponder. One additional thing I'll say about that, do read the Supreme Court decision in its entirety and go all the way to the end of the court's own opinion to get Justice Thomas's dissenting, his own individual dissenting opinion. It's very short. It's just 1 paragraph, 24 lines, but he is the only justice who truly understands the need to further limit the Commerce Clause, to really restore it to its original meaning, and he's the only justice who takes a real contextual view of the Constitution. Back to abuses of power by the presidency. The State of the Union address, the budget process. As I mentioned last time, the modern politicized State of the Union address with its pomp and circumstance, with the president addressing not just a joint session of Congress, but even having justices of the Supreme Court sitting in this political event, goes far beyond what the framers intended by the provision saying the president from time to time shall report to Congress on the State of the Union and recommend legislation. Jefferson would be appalled at the modern State of the Union address with its spectacle as a gross violation of the principle of separation of powers, and particularly having the Supreme Court there at such a blatantly political event. To see how truly political it is, consider the 2010 address by the current occupier of the White House, whom I call B.O. For the obvious reason. B.O. Lied about the court's decision in the Citizens United case, misrepresented it. That prompted Justice Alito, who was present there, being lectured by the president, to shake his head and mouth the words, "not true." State of the Union was never intended to be such a gross violation of separation of powers. Since the passage of the Budget and Accounting Act of 1921, presidents have been given statutory authority to prepare a budget, taking much of that power away from Congress. As I said yesterday, Congress has power over the purse strings. Lawmaking through executive order. There's a long practice of presidents issuing executive orders, properly so, to spell out how the executive branch should enforce the laws. But modern presidents have started to abuse the executive order power to actually make law, again usurping Congress's powers. FDR did it most infamously with the Japanese relocation order, the internment order. That was an executive order. Bill Clinton, Slick Willie, abused it widely, prompting his advisor Paul Begala to comment cavalierly, stroke of the pen, law of the land, kind of cool. No, kind of unconstitutional. Clinton used executive order power to set aside millions of acres of land as national monuments. He forbade federal contracts with employers who hired permanent replacement workers, despite federal labor law and a Supreme Court decision to the contrary. B.O. has abused it in many ways, granting waivers under the federal education law, No Child Left Behind, under the health care law, and most recently the controversial decision dealing with illegal immigrants under the age of 30, essentially giving amnesty to those people. That is an abuse of presidential power. That is remaking the law, something that B.O. himself recognized he didn't have the power to do until he became desperate now during the summer months leading up to the election. Lawmaking through the administrative state, the so-called fourth branch of government. Starting in the late 19th century, the Interstate Commerce Commission, but growing during both the so-called progressive era and particularly the New Deal era, Congress began creating these so-called independent regulatory agencies, these administrative agencies, alphabet agencies, FDA, FTC, SEC, FCC, FTC, NLRB, bring it up to modern times, OSHA, the EPA, the FEC. Now, what's the problem with these agencies? Well, by giving them not only executive power to enforce the laws passed by Congress, but legislative power to pass regulations, sort of filling in the gaps. Congress is unconstitutionally delegating lawmaking powers to these executive agencies. And because most of them have their own independent judicial proceedings through administrative law judges, they're also unconstitutionally delegating judicial powers as well. So the very existence of these administrative agencies is a gross violation of the principle of separation of powers because it unconstitutionally blends those powers. Now, the EPA, Environmental Protection Agency, in recent years, and particularly under the current regime, has been the agency I think most visible as a tool for the president to essentially do an end run around Congress. B.O. and his administration, with their war on carbon-based fuels, trying to get the so-called cap and trade legislation, the bill passed through Congress. They failed. So what does he do? He uses the EPA with its radical environmentalist director, Lisa Jackson, to implement those policies through EPA regulations rather than through laws passed by Congress. So doing an end run around the Congress by abusing the powers of these agencies, which by their very existence are already an abuse of constitutional powers. How much time do I have till questions?
You have 12 minutes if you want 10 minutes.
Okay, oh good, okay. Continuing on, abuse of the appointment power. The term czar was first used to describe the director of the Federal Drug Control and Abuse Policy in the early 1980s. You know, this was an office created during the Nixon-Ford administration, a person who directs essentially the drug control propaganda of the United States government. This practice of presidents appointing so-called czars who are not subject to Senate confirmation because they are described as presidential advisors rather than office holders is a practice that has become increasingly abused, particularly by the current occupier of the White House, B.O. There was an interesting op-ed in June, I believe, of 2009, just a few months after B.O. took office, saying that he had more czars than the Romanovs. And that's quite true. In their 300-year history, the Romanov dynasty of Russia had 18 czars, and by that time in his presidency, not even 6 months in office, B.O. had appointed more than 20 czars. I don't know where the count is now, but it's much, much higher than 20. At the time, the czars included, this is just a partial list, Energy Czar, Carol Browner, Urban Czar, Adolfo Carrion, Infotech Czar, Vivek Kundra, Faith-Based Czar, Joshua Dubois, Health Reform Czar, Nancy Ann DeParle, TARP Czar, Herb Allison, Stimulus Accountability Czar, Earl Devaney, Non-Proliferation Czar, Gary Samore, Terrorism Czar, John Brennan, some of you may know of him. Presumably, I've heard the charge made that he was the one who sort of leaked this news about our secret operations in the Mideast to the press to prove how strong BO is in the war against terror. Regulatory czar, Cass Sunstein, another infamous character if you've been following the news. Drug czar, of course. Guantanamo closure czar. You know, talk about a useless position, as well as several envoys who fall in the czar category. Maybe the most infamous czar of all that B.O. appointed was former Green Jobs czar Van Jones, who, as you know, is a Marxist, a communist. How's that? A red in charge of green jobs. Anyway. The power to make recess appointments, another power that B.O. has abused greatly, particularly this past year. Now, the Constitution does give presidents the power to, quote, fill up vacancies that may happen during the recess of the Senate by giving commissions that will expire at the end of the next session of Congress. But as you all know, B.O. abused that power early this year when he appointed Richard Cordray as head of the new Consumer Financial Protection Bureau, created by the Dodd-Frank law, as well as 3 new members, all of them pro-union, of the NLRB, the National Labor Relations Board. Now, he appointed these, he made these so-called recess appointments when the Senate was still in session. The Senate had taken steps to continue itself in session, pro forma. The Senate was not officially in recess because the Constitution requires the other House, the House of Representatives, to agree to its companion House recessing, and the House hadn't done that. Nevertheless, he did it because he knew he couldn't get these appointments through the ordinary Senate confirmation process. So not only is he appointing these czars who are exercising real power. Some argue that Cass Sunstein, the regulatory czar, maybe the most powerful man in Washington in the current regime right now. But in many cases, these czars, because they're labeled as presidential advisors, aren't even submitted for Senate confirmation. And then by calling some of these appointments recess appointments, B.O. has again bypassed Congress, and the constitutional checks and balances that the Constitution provides, Senate confirmation of presidential appointees. Abuse of the pardoning power and other powers. George Mason, prominent anti-federalist during the debate over the Constitution, feared that presidents might abuse their pardoning power. He said, presidents might be involved in a criminal conspiracy and then use the pardon to shield themselves from liability by pardoning their co-conspirators. Now, for many years, people thought that George Mason's fear was an example of how unreasonably skeptical the Anti-Federalists were. Men of little faith, they were called. Then along came Bill Clinton, Slick Willie. And some of you might remember in the 11th hour of his presidency, he issued a number of pardons. Financier, Democrat fundraiser, or donor Mark Rich was one of the people pardoned. But also among these last-minute pardons, Susan McDougal, who along with her husband Jim were involved with both Bill and Hillary Clinton in the Whitewater land fraud scheme. George Mason's fear about abuse of the pardoning power finally realized nearly 200 years later with Slick Willie's presidency. That brings me to the so-called executive privilege doctrine, first asserted, in modern times, famously asserted by Nixon during the Watergate tapes case. The Supreme Court, in its famous decision in U.S. versus Nixon, another example of the court doing its job, enforcing the Constitution, even in situations where it may be politically difficult for the court to do, because you had the court with a majority of Nixon appointees on it, including Chief Justice Berger, all issuing this decision which compelled President Nixon to release the infamous White House tapes, which of course led to the smoking gun that led to his near impeachment over the Watergate scandal. Bill Clinton, Slick Willie, as president, asserted executive privilege multiple times, most infamously in connection with the Paula Jones sexual harassment suit. And he gave a rather extraordinary argument that executive privilege should shield the president from even civil lawsuits while he's in office for actions he had done before he became president, which the Supreme Court, again, quite rightly slapped down, allowing the case to go forward. And that's what ultimately led to the whole brouhaha over Monica Lewinsky and Clinton's own impeachment and trial. Recently, BO, as most of you know, has invoked the executive privilege doctrine to cover up Attorney General Eric Holder's probable involvement in the so-called Fast and Furious operation by the Justice Department, this illegal gun-running scheme into Mexico. I think what's most frightening about the Fast and Furious operation is there's apparently an effort by the Attorney General and his Injustice Department to try to undermine American Second Amendment rights. They were going to use the results of that operation as propaganda to argue for more gun control laws. Now it's been exposed. Congress is investigating, exposing high-up connection, at least as far as Eric Holder, if not the White House itself. Congress issued a subpoena, and now the White House is asserting executive privilege to cover up that illegal activity by the Attorney General himself and others. So, modern presidents acting like monarchs or tyrants. What do we do about this? How do we restore the constitutional presidency? Well, first and foremost, we need to vote the current lawless occupier of the White House out of office. We should deny him the opportunity to be even more flexible during a second term. I'm referring, of course, to the infamous open mic gate incident, where BO assured the Russian president that on arms control, in giving in to Russia's demands, he can be even more flexible during his second term because he's not accountable to the American people. That's as he sees it, because he won't be running for re-election during his second term, thanks to the 22nd Amendment and the term limits that we finally got. I say let's not wait until November. Let's have Congress begin impeachment proceedings tomorrow, because his abuse of power is so extensive. I've argued on my blog, he is by far and away the most lawless president in U.S. history, that he really should be removed from office right away to spare the American people at least a few more months of his abuses of power. I similarly argued the same thing in October 1996, saying that instead of arguing about whether we should re-elect Clinton, Congress should impeach him and remove him. I think I was one of the first people to call for Clinton's impeachment. That was long before Monica Lewinsky, but more important things like Whitewater, Travelgate, Filegate, many other examples of abuse of power. I couldn't imagine a president being worse, being more corrupt than Clinton until the current regime came along. Obviously, the Romney campaign, the Republican Party ought to emphasize more the issue of abuse of presidential power, BO's contempt for the Constitution, as well as his contempt for business, capitalism, free markets, and so on. Ultimately, however, it's up to the American people to care about the Constitution, to educate themselves about the Constitution. It ought to be, as Thomas Paine called it, the political Bible of the state. Every family ought to have it, every member of government, who again, state and federal officials, all of them take oaths to defend the Constitution. They ought to read it sometime, including the justices of the Supreme Court. And members of Congress, Paine said, should carry around pocket copies of the Constitution and refer to it every time they vote on a bill. People also need to care about Congress and how it has abdicated power to the president. They should demand that Congress be independent and strong, not think of the president as a monarch, but think of him as a chief executive bound by the chains of the Constitution. I think the Tea Party movement and what it is doing to restore popular interest in constitutional limits will play a positive role in helping bring that about. And I will now stop so that Alexander won't have a heart attack, and we'll open the things up for questions.
All right. People could...
Thank you very much, David. That was just terrific. In conversation with you yesterday, you told me that you're working on a book on interpreting the whole Constitution in a different fashion than the originalism and so forth. I'm wondering, as possibly a concluding chapter in that book, might you consider spelling out how U.S. government, how different it would be if we could restore the original, or the, let's say, the right interpretation of the Constitution? What are all the changes that would happen? I think that would be extremely enlightening for people to learn.
Yeah, as you said, thank you for that question, Bob. The book I'm working on is called Freedom's Constitution, a contextual interpretation of the Constitution. At the summer seminar a couple years ago, I sort of gave an overview of the book, and yesterday I talked a little bit in part one about this contextual view interpreting each provision of the Constitution in the context of other provisions, the document as a whole, indirectly by writing in that book about how the Constitution ought to be interpreted. I will suggest how very different, fundamentally different things would be. Certainly how different it would be from what the Supreme Court has said the Constitution means. But that's a great idea. Maybe as an afterword for the book, or maybe a way of getting a second edition published. I could keep updating it every few years that way. Thanks. John.
If I'm remembering the story correctly, when Clinton invaded Bosnia, he was challenged, and he responded, well, it's not a war, it's an armed conflict. And after this, there was a legal challenge to him. Whatever happened to that?
My guess, again, as I said, usually whenever anyone challenges a presidentially initiated war, courts will cite this so-called political question doctrine and say, we can't decide that. That's an argument between the president and the Congress, the other two branches of government. It's about how the war powers are shared between those branches, and it's not for the judiciary to decide. So as far as I know, in almost every kind of case trying to do a challenge through the courts of any kind of presidential war power, courts just refuse to decide the question, citing this political question doctrine.
Thank you, David, for a wonderful presentation. So many questions, so I will restrict myself to one. Under usurpation of congressional legislative powers, you have here the budget process, and you didn't touch on that. Could you touch on that?
Well, thanks. As I briefly said, in 1921, right at the end of the so-called progressive era, Congress passed this budget and accounting law requiring the president to submit a budget to Congress as a kind of starting point. Congress can ignore the budget, as they have done. You know, it's interesting under the current occupier, his own Democrat-controlled Congress has totally ignored it, dead in the water there. Of course, the Republican-controlled House has come up with its own budget, which has no chance of passing the Senate, let alone being signed by the president. But essentially what that 1921 law did is sort of shift the initiative from the Congress to the president. So the Congress becomes almost like a rubber stamp on what the president says the budget needs of the country are, rather than Congress itself determining it, which I would argue is its responsibility because it was given power of the purse. As I pointed out in part one, there's a clause in the Constitution that explicitly says no money should be drawn from the Treasury except in consequence of appropriations by Congress. In fact, some of you might remember before the Watergate scandal, Nixon was accused of creating an imperial presidency because of his practice of impounding money, not spending all of the money appropriated by Congress. So it was long believed that Congress should decide what to spend money on, how much money should be spent, and so on. Essentially now it's the president that makes those decisions unless Congress acts to countermand what the president has said. And usually when they do that, they increase the money that the president requests for in his appropriations, which is part of the reason why we have such a horrible problem with deficits and the national debt.
I appreciate that you wouldn't want to use the word health care in regards to that act, but why would you use insurance in regard to it?
Well, I said it's a health insurance regulatory law. It essentially, it transforms the United States into the term socialized medicine is somewhat misleading. We have socialized medicine with Medicare, Medicaid, the VA, and so on. The other part that has private insurance, the federal law, the 2010 federal law, essentially creates, I would call it, fascist medicine, because you have government so regulating private insurance that it no longer really is in the private sector. It's a government. It is in real terms a government takeover of the health insurance market. I believe deliberately designed to destroy private insurance. So it's a step towards true socialized medicine. B.O. said just as much himself when he was speaking to leftist groups. He said, you have to understand, we have to take this one step at a time. Pass this law, and because the individual mandate, the penalty now, doesn't even apply to people who don't have to pay income taxes, is set so low when it's initially phased in that most people find it better to just pay the penalty rather than pay. Insurance companies will find they'll rue the day for their support of the law, because it's unsustainable. If the law goes into effect, one by one, private insurance companies will start going out of business, and then the left will say, aha, now we need government monopoly on health care, which was their ultimate aim all along.
Excellent talk as usual, David. I noticed, I realize you probably have constraints of time. There's only so much you can cover. But do you have any general thoughts about the theories of the unitary executive advanced by John Yoo most recently? As I understand the argument, he seems to think that when it comes to international relations, war powers, things like that, that the president is pretty much unlimited, subject only to the power of the purse, which of course is kind of a wink and a nod, because he knows that politically it would be very difficult for Congress to move forward, because then the accusation would be, oh, well, you're not supporting the troops. You're not giving them the tools they need to do their job. But anyway, as you understand the argument, what would be your basic, critique of the theory?
Yeah. Well, I'm glad you mentioned John Yoo, because he is probably the leading example of an advocate of what I would call the Hamiltonian position, the very broad view of presidential powers, including in the war powers area. Yesterday when I talked about Hamilton's opinion about the president, once war has started, the president can wage the war himself without any authorization from Congress. Yoo, I think, takes that position. I disagree with him. I think he fundamentally misunderstands the way the Constitution does share the war powers between the President and Congress. In other respects, though, I do agree with the modern theory of the unitary executive, and this is particularly in connection with these so-called independent agencies, these administrative agencies, because by delegating some executive power to those agencies, they're called independent agencies because they're staffed by a small number of commissioners who are given lengthy terms, often 7 years or more, and they're staggered, so no one president in one term can totally remake the commission. Some of them by law, like the Federal Election Commission, are mandated to have equal number of Republicans, equal number of Democrats. But still, as I mentioned with my example of the EPA, presidents can try to control those agencies. And so the Constitution created a single chief executive, the president. These agencies shouldn't exist, and so to that extent I do support a theory of a unitary executive, even though they may not be necessarily what Professor Yoo is talking about. Alexander.
All right, thank you very much for the talk and answering the questions. Thank you everybody for coming. We'll have another session in 15 minutes.